The Supreme Court just handed President Trump a major legal victory, striking down Judge Boasberg's nationwide injunction that halted Trump's deportation plan. Join me, Benjamin Barr, the constitutional litigator, as we continue to unwrap nationwide injunctions. If you've been following this channel, you know I called this outcome weeks ago. In this final installment of our series, I want to wrap things up and shift the spotlight. How do we prevent the cycle from repeating? One judge, one case, freezing national policy for 330 million Americans. Today we're looking at how to reform nationwide injunctions, not to help one party or the president, but to restore the balance of power and bring the stability back to the rule of law. Everyone should welcome that. In this video, we'll examine what went on with the Boasberg ruling. We'll jump next to what Senator Chuck Grassley has proposed as sensible reform. And we'll examine a decidedly bad idea, impeaching judges, and move on to other serious reform efforts. But first, let's examine what started this controversy in the first place. In recent months, there have been clashes between the judiciary and President Trump over broad orders that have reached a fever pitch. The controversy recently flared when Judge James Boasberg of the D.C. Federal Court issued a nationwide order blocking a mass deportation plan by the Trump administration. President Trump had invoked a 1798 wartime law, the Alien Enemies Act, to deport alleged members of a Latin American gang, even flying deportees out of the country in secret. Boasberg intervened with an emergency injunction stopping all such deportations temporarily while the case was litigated. This meant that no one, not just the few plaintiffs who sued, could be deported under the disputed policy until the court said otherwise. Boasberg's injunction didn't just press pause on a handful of cases, it froze national policy. The judge even contemplated holding officials in contempt when it appeared some deportation flights went forward in defiance of his order. The implication was clear. A lone judge can stand in the way of the executive branch across the entire country. Supporters of such injunctions argue that when a policy is likely unlawful or unconstitutional, one judge must be able to stop the harm for everyone at once, rather than leaving thousands of affected people to file identical lawsuits here and there. But critics counter that the power goes too far. Beyond the power of resolving dispute of the parties in court, it lets one judge effectively veto a federal policy throughout the country. Now, as an aside, I covered the substance of these lawsuits in other videos addressing the Alien Enemies Act. My prediction was simple. The judiciary usually doesn't second-guess the executive when it comes to matters of national security or deportation, especially under the Alien Enemies Act. I noted how the Supreme Court upheld Truman's use of it after World War II in the Lutke case. Sure enough, the Supreme Court cited Lutke and noted that these kind of determinations largely preclude judicial review. As I also pointed out, the court called for basic due process to be observed, and assuming it's met, for the use of law to satisfy the Constitution. But before the Supreme Court ruled, Judge Boasberg's ruling prompted a furious reaction. On social media, President Trump blasted the unnamed judge, clearly Boasberg, as a radical left lunatic and declared this judge should be impeached. To Trump, Boasberg's injunction was sabotaging a policy he deemed vital. It wasn't the first time Trump bristled at judges thwarting his agenda, but calling for impeachment escalated the rhetoric. He accused Boasberg of being a troublemaker and basically a political enemy in a black robe. These unprecedented attacks alarmed many in the legal community. Chief Justice John Roberts issued a rare public rebuke, reminding everyone that for over 2 centuries, it's been settled that impeachment is not an appropriate response to disagreements with a judicial decision. Instead, the proper path is through appeals, not punishing judges for doing their jobs. Other legal experts warned that fiery rhetoric from powerful figures could erode judicial independence and even endanger judges. Indeed, federal judges reported a spike in threats amid the impeachment talk. The clash was no longer just legal. It had become deeply personal and political, pitting the executive and its allies against the guardians of the law. Beyond heated words, concrete steps are being proposed to address the nationwide injunction problem. Senator Chuck Grassley of Iowa, the ranking member and former chair of the Senate Judiciary Committee, has introduced legislation to rein in what he calls judicial policymaking. In a commentary announcing his Judicial Relief Clarification Act, Grassley argued that district judges have inappropriately inserted themselves into national policy debates by issuing injunctions that affect everyone, not just the plaintiffs. He cited startling statistics. No recorded universal injunction existed before 1963. But in recent decades, they've exploded. Over 2/3 of all the nationwide injunctions in the last 25 years were aimed at Trump's first-term policies. And in the first 2 months of Trump's new term, at least 15 nationwide orders have already been issued, more than President Biden faced in 4 years. He was at 14. The trend, Grassley says, shows how activists have turned these injunctions into a favorite tool to derail a president's agenda. Grassley's bill aims to restore the court's constitutional role by limiting the power of any single judge. The, quote, obvious solution, he explains, is to restrict federal courts resolving the case before them and the actual parties. No more, no less. Under his proposal, a district judge could not issue an order stopping the government from acting against non-parties nationwide. In other words, if 5 people sue, the relief can cover those 5 people, but not the whole population of the United States. If a policy truly needs to be blocked broadly, it would require either a class action lawsuit or higher court's intervention. Grassley also targets the quick trigger TROs, temporary restraining orders, that some judges have used to freeze policies on short notice. His bill would make any TRO against the government immediately appealable, ensuring that rash decisions handed down in the heat of a political moment can be promptly reviewed by an appellate court. Importantly, Grassley insists this isn't a partisan crusade. He notes that Democrats have also bristled at nationwide injunctions when they were on the receiving end. In 2023, 240 Democratic lawmakers, including Senators Schumer and Durbin, filed a brief warning of perilous consequences after a single Trump-appointed judge in Texas moved to ban an abortion pill nationwide. Even liberal Justice Elena Kagan has expressed dismay at the idea that one district judge can stop a nationwide policy in its track for years through such injunctions. Grassley's message: both sides have seen the danger of government by court injunction, and it's time to diffuse it. Republicans and Democrats alike have cheered or criticized nationwide injunctions depending on whose ox was being gored, he observes. But that only politicizes the courts and upsets our constitutional balance. By rallying bipartisan concern, Grassley hopes to gather support for reining in what he views as an unconstitutional judicial power grab. Amid the current chatter about impeaching judges over controversial rulings, for example, calls to oust Judge Boasberg after one of his decisions, it's worth remembering a dramatic lesson from history. In 1804, President Thomas Jefferson's allies in Congress did try to remove a Supreme Court justice purely for his judicial decisions, and it almost backfired catastrophically. The target was Justice Samuel Chase, an ardent Federalist appointed by George Washington. Chase was impeached by the House of Representatives on 8 articles, accusing him of biased partisan rulings and intemperate courtroom conduct, whatever that may be. This was essentially a political hit job. Jefferson and his party wanted to rein in Federalist judges, and Chase, a signer of the Declaration of Independence, with a sharp tongue, was in the crosshairs for what he said and decided from the bench. The Senate impeachment trial of Justice Chase in 1805 was high political drama. Vice President Aaron Burr, fresh off his duel with Alexander Hamilton, presided as Chief Justice John Marshall watched from the gallery. Chase defiantly argued that he'd committed no crime, no misconduct. He'd merely exercised his judicial duty, even if his Federalist leanings might have shown. When the final votes were tallied, not a single article gained the required 2/3 majority to convict. Chase was acquitted on all counts and kept his seat, marking the first and only time a Supreme Court justice had been impeached. More importantly, his acquittal established a pretty crucial precedent. Impeaching judges for their decisions or beliefs rather than outright wrongdoing is a dangerous path to go down. Even many senators of Jefferson's party balked at crossing that line. The lesson from the Chase affair was clear. Using impeachment as a political weapon against the judiciary threatens the independence of the courts. After 1805, thankfully no justice has ever faced impeachment for judicial actions. The Chase episode stands as a stark warning that America should never make a habit of ousting judges simply because politicians dislike their rulings. Justice Chase's trial forged an enduring principle. Impeachment is reserved for grave misconduct, not routine ideological disagreements. We do have a constitutional mechanism to remove judges, but it was meant to be used sparingly, only in the most egregious circumstance, folks. History bears this out. In over 230 years, only 15 federal judges have ever been impeached by the House, and just 8 of them were convicted and removed by the Senate, an extraordinarily rare event. That averages to 1 judge removed roughly every 30 years. By design, it's easier to find a unicorn than to see a judge impeached in America, and that's a good thing for judicial independence. All of the few judges who were removed met a very high bar of misconduct. We're talking about blatant, unforgivable behavior, far outside the bounds of judging. For example, during the Civil War, Judge West Hughes Humphreys was impeached and tossed off the bench for defecting to the Confederacy, literally abandoning his oath to serve in a rebel government. In another case, in 1989, Congress impeached and removed Judge Alcee Hastings after evidence showed he solicited a bribe in exchange for lightening a defendant's sentence, and then lied about it under oath. Fun note, Hastings later went on to proudly serve Florida in Congress from 1992 to 2021. I can't make this stuff up. More recently, in 2010, the Senate removed Judge Thomas Portis for a pattern of corruption and perjury. These cases involved judges who were drunk on power, mired in corruption, or betraying the nation. In short, they had it coming. By contrast, disagreeing with a judge's legal philosophy or a single controversial ruling is nowhere near the high crimes and misdemeanor standard the founders envisioned. That's why calls to impeach judges like Boasberg or any judge who issues an unpopular opinion are profoundly misguided. Impeachment should remain the absolute last resort, a constitutional fail-safe for extreme misconduct, not a routine tool of political retaliation. If we weaponize impeachment every time a judge irks us, the judiciary's independence will be shattered, and our system of checks and balances collapse. So if not impeachment, how do we address actual, genuine concerns raised by one judge issuing sweeping nationwide orders? That brings us to the real issue at hand, nationwide injunctions. Nationwide injunctions, when a single federal trial judge can block a law or policy across the entire country, it can pose a serious challenge to our constitutional balance. Even Supreme Court justices across the ideological spectrum have flagged the problem. Justice Neil Gorsuch, for instance, has warned that a single adverse ruling out of 94 district courts can put a federal policy on ice nationwide that invites gamesmanship and chaos in our legal system. Conservatives and liberals alike have watched advocacy groups shop for friendly judges to freeze policies they oppose, whether it's a Trump immigration rule or an Obama environmental regulation. The result is whiplash and uncertainty as national policy swings open and shut based on one judge's order. Clearly, this isn't how our founders imagined the judicial branch would function. But the answer isn't to attack the judges personally. It's to fix the rules that allow the situation. Serious legal minds have offered various reforms to rein in nationwide injunctions while preserving the court's vital role. We discussed Senator Grassley's efforts, but there are several other reform ideas gaining traction in scholarly law reviews and on Capitol Hill. Limit emergency TROs. One problem is judges issuing temporary restraining orders that instantly halt a policy nationwide without a full briefing. Some propose curbing this by making any nationwide TRO expire very quickly or be immediately appealable to a higher court. By requiring quick appellate review of broad TROs, we ensure emergency relief is truly temporary and subject to higher court scrutiny. Here's another idea. Use 3 judge panels. Any request for a nationwide injunction be heard by a special 3-judge court. Instead of a single district judge, you'd get a panel, for example, 2 district judges and 1 appellate judge, to jointly decide whether to issue a nationwide order. Congress has built special 3-judge panels in a variety of special areas of the law. It's probably a good idea to have them here. A decision by such a panel could go directly to the U.S. Supreme Court for review, bypassing normal lengthy appeals processes. And a multi-judge panel would reduce outlier injunctions, increase consistency, bolster public confidence. I like this idea a lot. How about expedited appeals for injunctions? Many observers urge that any nationwide injunction should trigger an automatic fast-track appeal. Normally, litigation can drag on for months and years. Trust me, I've been there. But when one district court stops a federal law or regulation nationwide, higher courts should resolve the issue faster. Proposals include giving the government an immediate right to appeal injunction orders and requiring appellate courts and the Supreme Court to prioritize these cases on their dockets. Geographic limits, circuit-wide injunctions. Some scholars contend that injunctions shouldn't automatically apply nationwide. Instead, the scope could be limited to the court's own jurisdiction. For example, only the states within a particular court's circuit. Traditionally, one circuit's rulings don't bind other circuits. Nationwide injunctions seem to defy and short-circuit that process. So defaulting to circuit-wide injunctions would stop one district judge from effectively making nationwide law for the whole country. Each of these reforms has pros and cons, but all share a common goal: rein in the ability of one lower court to control national policy while preserving meaningful judicial review of government actions. There are smarter ways to address nationwide injunctions than impeaching every judge who issues one. Nationwide injunctions raise legitimate concerns. They upset the separation of powers and enable partisan litigants to cripple federal policy. We can do better. Conservatives should push for reforms that restore balance. But the cure for judicial overreach is not impeachment, not throwing impeachment grenades at judges we dislike. If we go down that path, we politicize the judiciary and erode the rule of law. Take a moment to study what I shared about Justice Chase and Thomas Jefferson if you have any doubt. The right response is to change the law, not punish the empire. We can set clearer rules, expedite reviews, reinforce judicial independence. The solution: fix the process, don't attack the person doing his job. By doing this, we preserve constitutional balance, ensure fairness, and reaffirm that judges must remain impartial umpires, not political targets. Thanks for joining me, Benjamin Barr, this time. And be sure to subscribe and like. Join me next week as we dive into yet another constitutional controversy. If you're still here, at the end of every video, I'm adding a little section called Ben's Notes, extemporaneous notes about what's going on in my life. 2 things to share this week. As we moved into this week, we have filed a petition with the U.S. Supreme Court challenging Oregon's recording law on the basis of the First Amendment. That's got a lengthy story, but Oregon has one of the weirdest and broadest laws for how you record in public conversations, something reporters do every day. We think it a deep First Amendment infringement, and we're excited to see that case develop. We also have a number of amicus, friends of the court, policy groups from the left and from the right who use these tools and have their First Amendment rights affected, who will be filing some briefs in about a month as well, and just delighted to see that bubble up and get support. Second, I think you'll notice we've got a little better quality this week. I'm not a filmmaker by trade, I'm a litigator, and I'm learning all this. So we have some definitely better technology working for our indoor shots. As we progress late spring, early summer, we'll be doing some field trips, and I'll use my other camera. It's better outdoors. We'll be seeing some of the great constitutional sites, talking about some of the great cases, and actually seeing it in person. But for now, great new technology to use indoors, and I think upping the quality quite a bit. All right, stay tuned to next week.